Here.
Judge Hernandez,
Present.
Judge Nguyen O'Dowd,
Here.
Judge Prats,
Here.
and Judge Truglia.
I am here.
Thank you very much. Looks like everyone is in attendance, Your Honors.
And I'm back. Can you hear me now? This is Joe Del Campo.
We can hear you now, Joe. Thank you.
Great. Sorry about that.
Okay, so I will call the meeting of the Rules Committee to order. I appreciate everybody's attendance virtually. This is we have a relatively long agenda for today's meeting. So we're going to try to proceed as expeditiously as possible. I would ask, as was already noted, that because we have so many people at this meeting, that you would make sure that your microphone is on mute if you are not presenting or talking to the members of the committee. So our staff has provided me with a list of everybody I believe who is requested to be a participant in this meeting. And I think I have a pretty good idea of who wants to speak to the committee about particular items. I'm not going to be able to do this completely on my own. So if Allison is on there as well, if somebody does want to speak, there is a icon on your screen to raise your hand. I can only see 9 participants at one time. So if you are not on my screen, I would not see it would not see your indication that you wanted to talk if I've skipped over somebody on a particular issue, if it's relevant to your participation in the meeting. So raise your hand, if you will. And Allison, maybe you could email me anybody that I'm not seeing directly. So
I am here, Your Honor, and I am happy to help.
Thank you very much. So this is the first, I guess, in-person meeting of the Rules Committee since the pandemic hit in March. So I should say that we had been doing a great deal of work last year, much of which was left in limbo when we were not able to have our regular meetings for the balance of the last court year. So just bear with us. Some of this is going to be old news for some members of the committee. We have new members of the committee who need to be brought up to speed on particular items. And I've asked Attorney Del Campo to frame, if you will, some of the subjects that are going to be discussed for the new members of the committee so we can all be on the same page. However, the first thing that is on the agenda is the approval for the minutes from the June 5th and August 28th meetings, and they have been previously distributed to the members of the committee. Is there a motion to approve both of those meetings? And I happen to see Judge Bella, so I'll accept it from her.
So moved.
Is there a second?
Second, Avery Whetstone.
Thank you, and thank you, Judge Avery Whetstone. If you are not on our screen, please identify yourself so that our minutes can be appropriately recorded to reflect that. Are there any changes to the proposed changes to the minutes for either of those meeting members of the committee? If not, all members of the committee, just members of the committee, please. All in favor, say aye.
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 Opposed, say no. That passes unanimously. The next item is actually a carryover from 2018, 2018-001, the proposal from the former Chief Disciplinary Counsel to amend sections 2-35, 36, 42, and 53. Attorney Del Campo, would you care to summarize this proposal?
Yes, this was made originally, as Justice McDonald said, in early 2018 by now Judge Carol Squilla. She was Chief Disciplinary Counsel. It was revised ultimately by Mike Bowler, the statewide bar counsel, and the grievance committee, and Attorney Brian Staines, the Chief Disciplinary Counsel. We did send it out to the committee sent it out to all the AJs and the CAJs, to the Connecticut Bar Association, the CTLA, the CDLA. The AJs and the CAJs that responded are in full support of this. The CBA did comment on the original proposal, but I don't see a comment on the revised proposal. And the CTLA and CDLA, I don't believe we've received any responses from them. However, I think some representatives may be in on this call, on this video today. And that's about it.
So if I understood the annotated version of my agenda, is Attorney Chapman on the call, and does he wish to address the committee? You're on mute, Bill.
How are we doing there?
There you go.
Okay. Your Honor, I don't think we had any comments from family law on the revised.
Thank you. Is Attorney Stovall on the call, and does she want to address this item?
Yes, Your Honor, I am here, but I believe the Ethics Committee has signed off on this proposal and has no objection to it.
Thank you very much. Is there any other interested legal entity on the call that would like to address this item? If not, just trying to scan to make sure. If not, are there questions from members of the committee? Is there a motion to approve?
So moved, Judge Bellis.
Moved by Judge Bellis. Is there a second from members of the committee?
Second, Avery Whetstone.
Thank you very much. Is there any discussion on the motion to approve members of the committee? And because I can't see everybody, just the members of the committee are feel free to just speak up without having to raise your hands. Okay, I am going to take that as acquiescence. All in favor, say aye.
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 Opposed, say no. That passes unanimously. The next item is also from 2018, 2018-003, the proposal from Judge Edelman to amend section 3-8 regarding hybrid appearances. Attorney Del Campo, would you summarize this?
Sure. This was first submitted by Judge Edelman and in September 2018. That proposal would have prohibited hybrid representation absent the express permission of the presiding judge for good cause shown. There was then a working group was then formed. I believe it included Judge Edelman, Judge Heller, Bellis, and Albus at least. That was put together for family, and the rules were put together, and then it was suggested that this may work in civil. Judge Abrams did canvass his civil side of the court, and they decided that they did not want this in civil. It was redrafted a couple of times, once to include civil and then once to take civil out. At this point, the last we met, Judge Heller was to contact, she was the contact person, and she was going to see whether or not technical changes to the family e-filing system have been implemented to allow parties represented by counsel to view pleadings and receive notices. I believe Judge Heller was going to be on this in this conference as well. So that's where we stand now. We have it drafted just for family, and Judge Heller was going to figure out whether or not technical changes were made to the e-filing system to be able to allow parties to receive notice.
And I do see Judge Heller as an attendee in this meeting. If she would activate her audio and visual, we'd be happy to hear from her.
Okay, I think I'm with you.
You are.
Justice McDonald, thank you. And my understanding in response to the immediate issue is I believe family litigants now are able to access their files without filing an appearance. I will tell you, I haven't had discussions about that recently. Of course, we've had some interesting things happen since we were all last together. But that is my understanding. I can confirm that, perhaps even during the meeting if you would like me to do that, but I believe they now have access to their files the same way I think civil litigants can without having to appear.
Thank you. And I believe, well, actually, Attorney Chapman, did you have any report from the CBA?
I'm sorry, I don't have any report from them. I think that, to be honest with you, it probably got dropped, and I'd be happy to receive comments, send it to them again.
Okay. As long as we're on this item, is Attorney Slager on the call? Don't see him. Joe, do you think we should just hold this off for one more month so we can get everybody on the same page, or what's your recommendation?
Well, we could do that. I'm just wondering, does the technical assistance that Judge Heller was explaining, does that obviate the need for this or no?
Well, I have to confess that I always heavily relied on Judge Heller for her advice on this, so I'll let her weigh in.
Okay, let me, I'm still with you. I think it still presents an issue because while there may be some family litigants that file appearances just so they can access their file, we also have family litigants that want to participate actively in their cases. Sometimes that's quite helpful. Sometimes it can make difficult cases even more difficult. So if you would like to, I mean, the issue has been kicking around for a while. I think we have a lot of different viewpoints and concerns. If you want to table it for another month, I'm happy to get involved again. I actually think Judge Edelman is also on the call and he may have some thoughts.
Is Judge Edelman on?
Yes, I am.
Please proceed.
Thank you. Actually, the technical issue of accessing the e-filing was brought up as a potential problem with the first draft. And I think Judge Heller is absolutely right. The accessing of the e-file by the self-represented party was not really a major issue for us. What is a major issue for us is having both an attorney representing the party and the party representing itself, especially in our more complicated and long-standing family cases. So we would get issues where the self-represented party would file a motion with his or her attorney having absolutely no idea about that. The other side would be legitimately questioning whether or not they can discuss this with a self-represented party or whether they had to go through the attorney. There was a lot of filing of repetitive and nuisance motions filed by the self-represented party. So the idea was that we wanted to get the attorney to be involved, but the court had some more control over what was going on, since the self-represented parties were limited in what we could do other than seeking contempt or something on that line. You know, the attorneys with their professional responsibilities, we felt there'd be more control. And it would also be clear to the opposing counsel who they could speak to and who they can't speak to. So I know, talking to Jim Abrams, this has not really been a problem in civil, but it's a tremendous nuisance and a problem in family with those cases that are repeated short calendar after short calendar.
Thank you very much. And actually, I need to get in the habit, once you've talked, if you could lower your hand so we can keep a track of who's, thank you. So at this, I guess for Judge Heller and Judge Edelman, well, let me ask you this question, then I'll open it up to other members of the committee. From your viewpoint, would it be a problem if we delayed this for one more month so we could get our, truthfully, I have to get myself back into this. I've been doing a lot of other things as we've been trying to ramp up, and I don't feel like I have my arms around this completely again. I had to dust it off, and I need a little more time if that's okay with you guys.
I don't think it would be any problem at all, especially given the limited cases that are coming forward at the time.
Yeah,
okay.
It would certainly be fine with me. I think it's a good idea to revisit it, particularly now that we're getting up to speed on doing virtual hearings. So I think the timing would be better in October.
Okay. From members of the committee, are there any questions that need to be asked now, or is there any objection to holding this for a month? Okay, we'll hold this for a month. Thank you both.
Great.
Thank you.
Thank you. Thank you.
The next item is 2019-001, the proposal from Judge Alexander to amend Section 37-1 to allow for waiver of the presence of the defendant at arraignment. Attorney Del Campo?
Yes, Judge Alexander submitted the proposal, again, requesting that the judges be able to conduct arraignments without the defendant being present. Comments were received from several entities. One of our attorneys was assigned to this project, Kate Casaban. I believe she's on this call as well. She worked with Judge Alexander, and they redrafted the proposal, which was sent out for comments again to Office of Victim Services, Public Defender's Office, and several other individuals. We have received comments back. We do have a new proposal that was submitted by the Office of Chief Public Defender. It just came in March 13th, so this committee has not had a chance to review that. It is in the package. I mean, they hadn't had this is the first time that is being considered in terms of in that revision. So that's the status of it at this point. Kate probably can give you some more information on what the last revision was, but we do have a new recommendation from Chief Public Defender's Office. And just as everybody I'm sure understands, Judge Alexander has been elevated to the appellate court. Judge Gold, I believe, is the new CAJ for criminal. So I don't believe he's had an opportunity to look at any of this, although Judge Alexander would have been here, although they're hearing cases today. So she wasn't able to attend, but she's more than willing to assist in Judge Gold's understanding of all this.
Okay, what I do want to hear from Kate, but I would prefer if ultimately we have Judge Alexander and Judge Gold being brought up to speed on this, since there has been a passing of the torch as CAJ. I'd like to make sure that he was up to speed as well. But Kate, as long as we're on this item, why don't you share with us what you know and update us on that? And if you could just summarize whether everybody who had the revised proposal sent to them has commented, whether the comments are substantive or editorial in nature.
I am actually having trouble getting into my my folders for this. So I believe the comments from the Chief Public Defenders were substantive and were something that that would change a piece of this in terms of the the basis on which judges could grant this waiver. And I think when we crafted it, we had in the draft that from Judge Alexander, we had crafted it so that it was very specific in that it could only be waived in order to protect a defendant's other constitutional rights, such as the right to counsel and the Miranda rights and all that stuff. And the chief public defender thought that, from what I understand, the chief public defenders thought that that was not clear or not, maybe not broad enough, and wanted to change the reason for the granting of that to just good cause. And I haven't seen the new proposal from the public defenders, so so I'm not sure what their thoughts are now. But from what I understand, their original comments were they wanted to change the good cause piece.
This is Joe again. That is the major concern. It used to say for good cause shown. Now it's written in terms of necessary to protect the defendant's constitutional rights, and they thought that was less clear language, so they'd like to go to redo it. So
and I would just say that I know when we were drafting the language, we thought good cause might be too broad in what authority it might be granting judges, because presence at arraignment is a constitutional right. So saying good cause might have give judges the feeling that they could waive the presence for something less than what is necessary to protect a defendant's other constitutional rights, as opposed, something like convenience or scheduling or something, right? And this is really meant for when, the defendant really can't speak for him or herself, and we're just trying to protect other constitutional rights, the right to counsel and things like that. So.
Okay, I'm sensing we're all trying to just get back into the swing of things and get refocused on a lot of this work. I'm open to suggestions from members of the committee. It does sound like we need to analyze better what the chief public defender's proposal is, to get that to Judge Gold, to find a time to have Judge Alexander participate when she's not hearing cases. So I think we're going to end up holding this as well. But if there are any other action items that members of the committee think need to happen between now and our meeting in October, so that we're more up to speed or more prepared to act at that time, why don't we hear from members now? Okay, so we will hold that. Joe and Kate, thank you for your comments, and you take care, making sure that Judge Gold is briefed on all of this.
yes, thank you.
Thank you. Next is item 2019-003, the proposal regarding standard written discovery in medical malpractice cases. Is Judge Stevens on the call? He had indicated a willingness to continue to serve on this project that he has been working on for a substantive period of time. I don't see him on here. Joe, have you heard from him at all?
I thought he did accept, but Judge Bellis is on, obviously, and she, last time this was on in February, it was requested that it go over till September, such that the subcommittee would have enough time. But of course, other things got in the way, so I'm not exactly sure. This is kind of a housekeeping measure at this point, to see if there's been enough time to put a product out.
Yeah, we're just so everybody knows, we rather abruptly ended our work on our regular work, and took up a lot of emergency matters that needed to be addressed beginning in March. This is really our opportunity to try to start to pull together the strings that were left on the floor in March. So Judge Bellis.
Thank you. I did speak with Judge Stevens, and he did agree to continue on the committee. Judge Cobb's also on the committee. Our next meeting is Friday, as a matter of fact. We're meeting remotely. We're probably halfway there where we want to be. It's been quite a bit of work, but I'm thinking, I don't know, Judge Cobb, if you agree, maybe if we put this on in 3 months from now, we should have a finished product, a proposal at that point. We got interrupted. I think our meeting, we had several meetings that we had to cancel due to the coronavirus, but.
Judge Cobb?
It might be just a tad optimistic, but there's no reason not to put it on because we can always move it if we need a little bit more time.
Okay, so is that December that you're talking about?
Yes.
Sounds about right.
Okay, we'll put it on there. If we have to adjust, we will adjust as we have. Everybody's been adjusting to all sorts of things, so.
It'll keep us honest.
Okay, there you go.
Okay.
Next is item 2019-004, the proposal from the State Victim Advocate to amend several rules relating to crime victims and advising them of their rights. I don't, if I understand the comment, Joe, Attorney Pierre cannot be here.
I believe so. Yes, she had originally accepted, but apparently she's gotten tied up. So I don't think she's on the in the conference at this point. Again, for this one, Judge Alexander was asked to explore, let's see, notification and tracking options and to look into the new case management system. So again, with Judge Alexander's elevation, it's a little difficult to get that information. I'm sure she's willing to chime back in, certainly, and to give us that information. Perhaps, again, this is something that Judge Gold should be briefed on, and probably has to come back again, I suspect.
Okay, but I don't disagree with that he needs to be briefed on that. I'd rather not lose some of the work that's been done here, and there are some other folks, I believe, who are ready to talk about this, or at least make observations about it. Is Christine Rapillo on, and does she want to talk?
Thank you, Your Honor. I'm on. I don't have anything to add other than the comments that we submitted in writing, that we believe the changes that we proposed are, for the most part, covered by the current rules.
Well, I thank you, and I thank you for your succinctness, actually. And I see that Deputy Chief State's Attorney Kevin Lawler is on. Attorney Lawler, did you want to address this item at all?
I would just echo Attorney Rapillo's brevity of comments there. I think we will just stand with our earlier remarks.
Okay. Attorney Staines, did you want to address this item at all, or can it wait until next month?
It can wait till next month. I already provided a letter, and I agree with the two other speakers that I believe the rules already sufficiently provide for the situation.
Okay. Is Morgan Ruckert on?
Yes, Your Honor, and I would agree with Attorney Rapillo.
Okay, I am not prone to interfering with unanimity. So unless Attorney Stovall has anything else that she wanted to address on this item, I think we're going to hold it for a month.
Nothing to add at this point, Your Honor.
Thank you very much.
This is Marcy Stovall.
Thank you. Did I miss anybody on that item? That I don't see any hands. Okay. Item 2019-014, the proposal from Senator Looney, Senator Winfield, and Representative Staffstrom concerning pretrial discovery procedures in criminal matters. I think this is also a Judge Alexander project, but Attorney Del Campo, would you care to summarize it for the new members?
Yes. This proposal was, again, for March. A lot of work had been done on it. The materials are voluminous. Again, Kate Casabon was assigned to help Judge Alexander with the legal research of this, but there was a subcommittee of Judges Alexander, Cradle, and Truglia. I think Judge Truglia is on the call. Of course, Judge Alexander and Cradle both were elevated. So again, Judge Gold has not been involved at this point. Let's see. There were recommendations of the subcommittee. There was a revised draft, and that's what was to be presented in March. And Kate may have a little more information on what that entailed, but that's the state of it at this point.
Kate?
I think where we were with this one was the first time that the subcommittee's proposal was submitted to the committee. We had gotten a number of comments that I kind of set out in the proposal altogether, and the request from the committee at that point was to go through and actually decide whether and how those comments should be incorporated into the subcommittee's final proposal to the committee. And so the draft, the final draft, I think it's called the final recommendation from the subcommittee is what we decided to do, or what the subcommittee decided to do with our initial proposal and the comments that had come in on that.
So I think the best course here would be for the subcommittee and maybe Joe and Kate to get together with Judge Gold. I fear we're dumping a lot on him at one time. I'm sure he has a lot of other things he's getting up to speed on as the new CAJ. But Joe, do you think you could arrange to facilitate that with him at a time that would be convenient for him?
Sure.
I don't know what just happened to my screen. Did anybody else's screen? Okay. I'm not going to try to fix anything.
It appears that perhaps someone is sharing their screen, which is overriding all of our attempts to display it. I can see somebody's window in the back. It says their calendar, Bill C, join conversation, looks like some CVA documents. So I'm guessing this is somebody's desktop.
September 14th, right? If everybody could just check to make sure that you didn't inadvertently. All right, I think we're back. I don't know how that happened, but I appreciate everybody's cooperation. So the next item is 2019-16, the proposal from Judicial Branch Administration to amend sections 2-27, 2-27A, and 2-65 to adopt a new section regarding the administrative suspension of attorneys who fail to register or comply with Connecticut's MCLE requirements. Attorney Campo?
Yes, this is an outgrowth of the MCLE requirements. Hundreds of attorneys have failed to comply and say so on the registration form. And this was an effort to address that situation. And there's a few other items that the Statewide Bar Council has asked to clean up in this proposal for the registration. I think Mike Bowler is in the conference and can probably give us a much better explanation of this if he wishes. We have received many comments from many different entities in this proposal, but I think Mike is probably in a good position to explain, what the status of this is. This, again, it was a proposal that was requested by the Judicial Branch Administration. Mike has been the shepherd for this, and he could probably explain a little bit.
Attorney Bowler, good to see you.
Hi, thank you. Good morning or good afternoon, Your Honor. The operative version was submitted on January 23, 2020, and I believe the last version made two changes at the request of the Rules Committee following their meeting at the close of 2019. The first was that Section 2-27A, and I put these latest changes in bold, was to make clear that nothing in the MCLE rule would permit random audits of a lawyer's MCLE account. And second, the committee had asked for the rule to be changed to allow a full grace period following the non-complying year before a lawyer could be subject to administrative suspension for not complying with the MCLE rule. That was also added in Section 2-27BA, also in bold. I believe those were the last, at least the Rules Committee, those were the last two sticking points. I discussed the requests of the Rules Committee with the administration. I've basically been working, or mostly been working with Judge Bizzuto on this project. And the administration agreed that those were fine to add. And so the operative revision, again, I sent to Attorney Del Campo in late January, and that's the one that I think we're discussing. I see that it was on the February 2020 agenda. I don't recall why it was tabled. It may have been tabled to get more comments from the bar. And then, COVID came upon us, and I know that the Rules Committee has several comments regarding the revised proposal dated January 23rd. If anybody has questions about it, I'll be happy to answer to it, but to sort of follow the theme, we sort of stand on what we wrote and don't feel the need to explain it anymore. It has been on the agenda multiple times. It's been discussed with the Rules Committee multiple times. And again, just to sort of sum up, I believe that the latest revisions were the last two sort of sticking points with the Rules Committee about making clear that there won't be any random audits, which was never the intent, and to lengthen the grace period for attorneys to comply. And the rule has been written to provide a 1-year grace period.
Thank you. That's my recollection as well. But I will admit I lost track of this item. Were those revisions enough to assuage many of the attorneys who were opposed to this? My sense was nothing than this proposal's untimely death would have. But I don't know that, and so maybe you can bring us up to speed about the level of comments or concerns that are still being expressed.
It looks like the Connecticut Trial Lawyers Association and the Connecticut Bar Association both favor the proposal. Now, I know Attorney Stovall is on this meeting, and if I'm speaking out of turn for her, she can feel free to jump in. I know that in talking with the Fairfield County Bar Association, they still had concerns about the fallout effect of an administrative suspension. And to be honest with you, I don't have off the top of my head now what the New Haven County Bar Association's position was. I believe the Connecticut Defense Lawyers Association favored the proposal. And I don't know that there were any substantive comments from the Office of the Chief Public Defender. As for personal comments from members of the bar, I wasn't contacted directly with any personal comments. Really, the only back and forth I had was sort of a very professional dialogue with the Fairfield County Bar Association, where I think we just sort of agreed to disagree. But it looked like we did have some support from other bar associations, local and state. And again, the administration backed the proposal, including the revised proposal that was submitted in January.
Is Attorney Stovall still on?
Yes, Your Honor, this is Marcy Stovall. I'm still here. The Ethics Committee was not asked to take a position, and I don't think we did not take a position, but I would, but I agree with Attorney Bowler that the CBA position seemed to be no opposition, but a number of concerns and queries about it, which I understand Mr. Bowler believes have been addressed.
So I appreciate that. Attorney, is Bill Chapman still on, and does that comport with his understanding of the CBA's position?
Yeah, I'm still here. I think Amy Meyerson, who is our president, may be on the call also, and she may want to weigh in on this also. But after we had time to look at it, I think that what Mike had said, that the changes seem to be fine.
Okay.
The last changes.
Is it Attorney Meyerson?
Yes, this is Amy Lynn Meyerson. Mike's comments were correct. We did see some opposition from Fairfield County, but the CBA and the CTLA were fine with revisions.
Thank you. I guess we were also supposed to hear from Attorney Rapillo. Did you want to say anything about this item?
Just that we support it, Your Honor, consistent with the written comments.
Okay. What's the will of the committee? Are we prepared to move forward? Or Judge Bellis, looks like you wanted to say something.
Yeah, I'm uncomfortable going forward without hearing from the local bar associations. I think that they got interrupted by the pandemic, but I think they did want to weigh in, and it might be that the amendments satisfy them, but I do think the right thing would be to give them another opportunity to weigh in, since everything sort of stalled.
I think that's it. Attorney Bowler, I know you've worked hard on this, but I think Judge Bellis is right. Everybody is just trying to pick up the pieces of where they left off.
Yeah. Listen, I completely understand, and I'm sure, as you're aware, the judges have suspended. This has become more of an academic discussion for this year, because the judges have suspended the MCLE requirement for this year. So time is hardly of the essence in terms of getting this rule to the judges, because nobody's not complying this year. They can all check off yes next year on the registration form, because they don't have to do CLE this year.
This is our first meeting. What I'd like to be able to do is to pace this so that we are in a position to act at some point during this year, so that it can be voted on at the annual judges meeting. So I agree.
We will have. I'm sorry, I don't mean to interrupt. We will need time to implement this, obviously. So the more time we have to phase it in, the better.
So why don't I don't know. Maybe you could work with Attorney Del Campo to circulate the revised version from January of this year to all of the county bar associations, to have them put it back on their radar screen and ask them to weigh in again on the revised version.
I will. Thank you, Your Honor.
Okay. Anything else from members of the committee on that item? Okay. The next item is 2020-008, proposal from the CBA Pro Bono Committee and the Standing Committee on Professional Ethics to amend Rule 5.5 of the Rules of Professional Conduct to permit pro bono practice in Connecticut by attorneys licensed and in good standing in other jurisdictions. Attorney Del Campo.
Yes, we received comments from several entities. There was a revised proposal from the CBA that was received in March 13th. So I don't believe that's been considered at all in terms of the March 16th meeting was canceled. There were comments from, again, Mike Bowler and I believe Chief Disciplinary Counsel And that's where it's at this point.
Could you bring me back up to speed on what the March 13th comments were, or the proposal was?
Yes, 1 second, please. It was a new proposal, actually. 1 second. Sorry.
No, that's all right. Doing this all virtually presents challenges for everyone.
Coming up.
Judge, this is Craig Colomb from the Pro Bono Committee. I have the comments from the SGC in front of me if you want me to read it.
I appreciate that, yes.
Okay, this is from Attorney Bowler. The SGC noted the proposal does not track the language of Practice Book 2-55E, which authorizes retired Connecticut attorneys to perform pro bono work. Practice Book Section 255E requires pro bono work to be uncompensated and is limited to the provisions of legal services with formally recognized pro bono organizations. Unlike the CBA Pro Bono Committee's proposal, Section 255E does not allow retired attorneys to provide legal services with a member of the Connecticut Bar who is also working on the pro bono representation. Thus, the proposal will extend greater rights to attorneys who were never admitted in Connecticut over those who were but have since retired. The SGC acknowledged that Practice Book Section 2-15AC5 does permit authorized house counsel to provide these pro bono services while working with a member of the Connecticut Bar, but the SGC observed that authorized house counsel are certified as such only after a vigorous investigation into their competency and fitness to practice. And he also made some, Attorney Bowler also noted that the SGC observed that this, I'm sorry, did someone?
No, I mean, I appreciate that Attorney Bowler's live and in person, so maybe he can jump in here.
Yeah, I would just point out that the summary that was just provided was with regard to the original proposal made by the Pro Bono Committee, and the one that is now on the agenda is the revised proposal that was submitted 2 days after we wrote the letter regarding the first proposal. So unfortunately, Your Honor, at the end of the day, the Statewide Grievance Committee has not had the opportunity to review this revised proposal. I would note right off the bat, however, that it's still in Rule 5.5. And one of the issues the committee had raised in its letter is that this is a procedural rule and really belongs in Chapter 2 of the practice book. But again, I'm not speaking for the committee when I weigh into this revised proposal because the committee hasn't reviewed it yet. I expect that they'll review it in their October agenda, but we're just getting back up to speed. We're having our first committee meeting since March this Thursday. So we haven't had a chance to look at this, or the committee hasn't had the chance to look at this revision yet, and it would help to just table it to give us the opportunity to do so.
Yeah, I mean, we are all getting our sea legs back, so I totally understand that. Is there any objection to tabling this for another month until they have their meeting? When did you say your next meeting was?
Well, our meetings are always the third Thursday of the month, so if we could table it to November, if that's not going to cause a huge problem, that would be helpful, because then I could get something to Attorney Del Campo in writing following our meeting.
I appreciate that. That's fine. So that'll be for November. Next is 2020-009, the proposal by Judge Heller to amend Section 25-60A of the Connecticut Practice Book to conform to the requirements of Section 46B-6A, the general statutes regarding the procedure for court-ordered evaluation in family relations matters. Is Judge Heller still with us?
Yes, I just reopened my screen, so I am still with you. Thank you.
Okay.
This proposal it was actually on the calendar first on the day that I was in front of the Judiciary Committee, so it was not able to be with you. And then, of course, our March meeting was canceled. The proposed rule essentially tracks the language of the statute that was passed now a couple of years ago. I did work on this with Judge Albus. I had run my draft past him, and this incorporates his comments. I think it's fairly straightforward. I don't know if there are any questions about it. I'm not sure it needs additional input. It really does track the statutory language. The only addition is a provision that it shall include not just the estimated fees, but the estimated fee of the provider for testifying in court. That's just based on experience with parties who are surprised by the cost that they have to incur. And of course, these reports can't come into evidence unless the author is available to testify and be cross-examined. But otherwise, as you'll see, I think it's attached, the statute is attached, and then the proposed rule.
It seemed pretty straightforward to me, but Attorney Del Campo, did you see anything that would require referrals to anybody else?
Let's see.
Or your team?
Judge Albus was, if this was discussed with Judge Albus, I think that would be fine. That would be, where we would go with this. And if he's already worked on it with Judge Heller, I think that should be sufficient.
Are there questions from members of the committee? Judge Bellis?
Just procedurally a minor thing. We generally don't allow clerks to seal items, and I'm just wondering if we can change the language such that, we're just indicating that it'll be filed under seal. I'm talking new subsection C. Generally, to seal something, it has to be a judge's order, or we have to have a provision that it's filed under seal. I don't know.
That's actually in the statute, Judge Bellis, so that's the reason for tracking the language. The statute says that it shall be filed and the clerk will seal it.
Okay, then.
So that's the reason for the language. I agree with you completely, but the statute says the clerk will seal it.
Then I defer.
This gets into one of those things. Is that a proper balancing of branches for our procedure? But I'm not certain this is the test case that we would want to test that.
I agree.
Okay. Are there any other questions from members of the committee? Please raise your hand or just speak up, actually. If not, is there a motion to approve?
So moved. Avery Whetstone.
Thank you, Judge Avery Whetstone. Is there a second?
Second, Judge Cobb.
Thank you, Judge Cobb. Is there any discussion from members of the committee? If not, all in favor say aye.
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 Opposed say no. That passes unanimously, and I want to thank Judge Heller for her work on this item, and we actually voted on something, so that was great, other than the minutes.
Thank you very much. Thank you.
The next item is the proposal 2020-10, proposal from Judge Stevens to amend section 13-14 of the practice book regarding issuance of orders for non-suit or default for discovery violations. And he is not on the call, is that correct? Or on the meeting? Attorney Del Campo.
Yes, this is truly the first time this is being considered. It was brought on to the agenda for the March meeting. It was never considered. We have not, you have not discussed it or referred it out for comment. We typically do that with things that are being considered for the first time.
I'm sorry. Say that again, please.
You haven't discussed it or referred it at all. It was on for March 16th, but there was no discussion or referrals made. So typically you make referrals when these are the very first times that these are being considered.
So, right. So I haven't given this a lot of thought. I mean, I certainly would want Judge Abrams's input. The, who else would this typically have gone to? The CBA?
CBA, yes. CTLA, I guess.
Yeah. And
I think that's it.
Joe, CCDLA, the
Okay.
Civil Defense Bar.
Okay, right. I can refer that to those entities and Judge Abrams.
yeah, let's start there and see what happens.
Okay.
Okay. Item 2020-11, proposal from Attorney Lori Petrozelli, who's one of our fine attorneys, to amend section 14-9 to bring our practice book into conformity with the general statutes about the nomenclature for public authority. Attorney Del Campo or Attorney Petrozelli?
Hi, Justice McDonald. This is actually a very simple technical change. So if the committee does agree with it, rather than have it being treated as amendment, we'd ask that if you grant it as a technical change, we would just direct the reporter of judicial decisions to make the correction for this upcoming practice book. And it simply is that in section 14-9, section 7, the practice book uses some stale terminology. It's actually so stale it's from 2011, wherein Public Utilities Control Authority in 2011 was changed to the Public Utilities Regulatory Authority. So we just asked the committee to recognize that small technical change and treat it as such.
9 years later, we will recognize that.
Thank you so much.
Is there any objection from members of the committee to treating that as a technical change? Okay, thank you very much. 2020-12 was a proposal from Attorney Megan Wade to adopt the ABA rule of professional conduct 8.4 subsection G regarding harassing or.
I'm sorry to interrupt you, Justice McDonald, but that what you just granted was item 12 on the agenda, but there was a second item 13, another technical change.
Lori's on again.
It's not on my, maybe I have an earlier version of the agenda.
Okay. Yeah, there's one more. It has to do with section 25A1 to resolve some ambiguities in how references to certain sections are listed. Lori again has looked at that. Some of these things I will just say, the reporter of judicial decisions does have the ability, when you vote at your judge's annual meeting, does have the ability to make certain technical changes. But sometimes we find these things in other sections, things that you haven't thought about, that you haven't considered, and sometimes we raise them just because it would be better if you saw them and the reporter's office is unclear whether or not he wants to make the changes without your approval. So sometimes we bring them here, and Lori's understands them fully. So she'll let you know about this one.
Okay, so that's also considered a technical change?
Yes, Your Honor. This was actually raised to the reporter of judicial decisions and then brought to our attention. It was raised by Deputy Assistant Public Defender Daigle, and he noted in 25A1, subsection A, F, and it's very, very technical, but there is a reference here to an exception accepting subsections A, E, F, G, and H of section 1327, 28, 30 through 32. And Attorney Daigle had rightly pointed out that only section 1327 contains an A, E, F, G, and H. So we made a recommendation to just tweak the way we referred to it so that it's clear that the subsections A, E, F, G, and H only refer to 1327. And then likewise, a similar type of plural versus singular referral to the word sections in capital section I. Again, same thing, there's a reference to subsection A of 1733 and 17-41. But Attorney Daigle rightly pointed out there is no subsection A in 1741, so it would be better to refer to each section individually. So it's kind of just a hyper-technical change for clarity, which we ask permission of the committee to refer that to the reporter's office to make the correction.
Is there any objection from members of the committee to having that referral for the technical change? Hearing none, that's fine. I should say, by the way, and this is our first meeting. Again, we're just getting back up and running. We're going to have to come up with a cutoff time for materials to be submitted to the committee. I understand a lot of things were falling back into place, but we had a flurry of emails and trying to prepare for all of this with stuff coming in as recently as this morning was challenging. So we don't need to do that now, but for the members of the committee who have other things to do, it's kind of hard to adapt on the fly with stuff coming in late. I understand this was an exceptional meeting, but we're going to have to address that in the future, Joe.
Okay. Yes, we can do that. I mean, it's not atypical, so we could do that.
Right. Even if it's 2 days, even if it's 2 days ahead or something, it's too difficult with stuff coming in an hour or two before the meeting.
Right.
Yes. All right. So if I got the right version of the agenda now, it's 2020-12. Is that next, Joe?
Yes, it is.
And I understand that proposal was, as submitted by Attorney Wade, was being withdrawn in lieu of a proposal from the CBA. Is that correct?
Yes. Well, that is what Attorney Wade had suggested, and then we did receive a proposal from Attorney Thomas, the president-elect of the CBA. That was
so what I would propose to do, since again those materials just came flying through the door as well, or relatively recent, and I've seen a lot of email traffic about attorneys who are concerned by it. With the approval of the members of the committee, what I would like to do is consider that substituted proposal from the CBA through Attorney Thomas to be the operative proposal, and that we use that as the basis to refer it out to the various bar associations of the various counties, so that we can re-engage this discussion around a proposal that has been more thoroughly developed. People may still have concerns about it, but it's a different document, and I think the discussion among members of the bar should be focused around that document rather than the document that Attorney Wade had circulated. To members of the committee, does that sound like a wise course of action? And I only see 2 members nodding, so I'm hoping the others are nodding as well. Is there any objection to doing it that way from members of the committee? I fear that, given the emails, that this will just turn into a cacophony of voices that's not as focused and shaped under a structure that's going to be meaningful to the advancement of the proposal. I know there are a number of people on here who probably wanted to address it, but I'd like to hit pause on that so that we can send it out to the various bar associations. And I was just thinking of county bar associations, but there might be, we probably should actually focus on the affinity bar associations as well. So the George Crawford Society, the LGBT section of the Bar Association, maybe Attorney Chapman can help get a list of the affinity bar associations to Attorney Del Campo, so that we can make sure that this proposal is circulated widely among any interest groups. And if there's anybody else representing a group on this in this meeting that would like to have a quote unquote official role of commenting through an organization that I have not identified, please reach out to Attorney Del Campo, and then we can bring this into again, a framework that's going to be more constructive. Is there any opposition for members of the committee to proceeding in that manner? Okay, thank you very much.
Justice McDonald, if I may.
Who's yes.
Cecil Thomas, hi.
Yes.
President-elect of the Connecticut Bar Association, we did submit the Connecticut Bar Association's proposal in lieu of Attorney Wade's to allow precisely for that referral for comment. I would just ask that the proposed rule also be referred to the Grievance Committee and Office of Disciplinary Counsel for their comment as well.
Yeah, that's a great suggestion. I'm not professing to have covered the total landscape of groups or organizations or institutions that need to weigh in, but I appreciate that. And congratulations or condolences on your new role. It's a hard job. I'm happy that you've taken it on. Is there anything else on our agenda, Joe?
Judge McDonald?
Yes.
Attorney Zenas has his hand up. I don't know if you see that.
Thank you. I did not see that. I appreciate it. It takes a village to support me. I appreciate that, Judge Cobb. Attorney Zenas?
Yes, Your Honor. Thank you. I was among the speakers who were prepared to proceed with arguments against the proposed rule today. I know the First Amendment Lawyers Association will be among those groups filing amicus briefs, expressing their concerns about the First Amendment. I will add that when Your Honor talked about the affinity groups and getting a broader perspectives, I will comment that 2 states' attorneys generals, both from the states of Texas and Tennessee, have issued formal legal opinions opining the proposed ABA model rule upon which this rule is based as unconstitutional. So I might submit as a recommendation preliminarily that in addition to those entities that you have identified, that you reach out to the state Attorney General of Connecticut to perhaps get a formal opinion from their perspective as we weigh in on this issue.
So I appreciate that suggestion. So for those who haven't necessarily participated in these types of meetings before, let me just share with you when we have a new proposal like this, we tend to send it out to kind of the regular participants in this process, and then we find out how much consensus there is and how much opposition there is, and that typically leads to secondary or tertiary lines of inquiry where we engage additional folks for more refined commentary once we understand what the scope of the problems and the opportunities are. So I appreciate your suggestion. I think it's slightly premature at this point. But by the way, if you are going to be submitting, I know you submitted some, I did see some materials from you, but if you have those opinions from other attorneys general, you should absolutely incorporate them into the response that you sent to Attorney Del Campo.
They are, Your Honor. They appear as exhibits in the appendix.
I didn't get through all of it because, again, it came in kind of late. So I appreciate that. Okay. Attorney Del Campo, was there anything else we had on our agenda?
No, sir.
All right. Before we adjourn, I just want to thank Allison Chandler and all of our staff for the committee on recreating or reimagining the way we are conducting our business. Everybody is out of their field of expertise with a lot of this technology, but we are adapting under trying circumstances. It doesn't go without our appreciation to everybody in the background who's making it happen to allow us to carry the business of the committee forward, and I do appreciate it. I know all of the members of the committee do. With that having been said, is there a motion to adjourn?
So moved.
Moved by Judge Bellis. Is there a second?
Second, Judge Cobb.
Moved, seconded by Judge Cobb. All in favor, say aye.
Aye.
Opposed, say no. That passes unanimously. Thank you very much, everybody.
Thank you.